Hi guys, welcome back to Battle with Ola. This is Mojola Olua and I'm super thrilled to be here once again. Today is another day that the Lord has made for us to talk about judicial precedents. And in this video, on this episode, we're going to be talking about Dokubo Asari and the federal government of Nigeria. It's a very important case. It's a notorious case. It's a case that's been used, nay overused, by criminal litigation lawyers in Nigeria. If you're a criminal litigation lawyer and you have used this case before, please bear me witness in the comment section. As an ex-prosecutor myself, this is a case I've used in response to affidavits for bail. I've used it severally in my counter affidavits. If you're a criminal litigation lawyer, and especially if you're involved in bail, whether you're opposing it or applying for it, you would use all these cases: Dokubo Asari and FGM, Bamaye and the state, Abacha and the state, and so on and so forth. Today I want to talk about Alhaji Mujahid Dokubo Asari and the federal government of Nigeria. It's a very interesting case and we're going to delve into it comprehensively. I hope that you will learn, and I know that you will actually learn, whether you're a lawyer, a law student, or a layman. I want to thank everyone that's been following the channel and supporting us. Thank you so much for the views, for the likes, for the comments, and for the shares. Thank you. Trust me, I see all those things at the back end. How you share, how you like, the volume, and it's really good for the channel, because we're doing something important and something great here, and it is our desire that it will go to the ends of the world and everyone that needs it will get it. Thank you so much. In the last episode, we talked about Garba University of Maiduguri. That's also a judicial precedent that's premised on fair hearing. This one is premised on fair trial and on the constitutional provisions and fundamental rights to personal liberty and presumption of innocence of an accused person. So we're going to be talking about it in detail. If you haven't watched the video we did in 2021 on bail, please go and watch that video. It may be a great precursor to this particular episode. Also, it's also very instructive or very expedient to just watch the entire playlist on criminal litigation on the channel. Check the playlist section and just click it and watch it. Thank you. Let's talk about Dokubo Asari and the federal government of Nigeria. Dokubo Asari is a leader of the Niger Delta People's Salvation Front. Then he became the leader of the Niger Delta People's Volunteer Force, and also a member of the Pro-National Conference Organization. During the tenure of President Olusegun Obasanjo, particularly in 2005, he began to issue threats against the government, making allegations of embezzlement of the oil revenue, fingering the state government, the local government, the federal government, and the Niger Delta Development Commission. He started threatening, to incite violence, to fight until Nigeria disintegrates. That's a direct quote. And then to issue several other threats. He was also fighting against the poverty that had ravaged the Niger Delta area, despite the fact that that was the oil producing, that is the oil producing area in the country, and oil revenue is a big portion, a big feature of the Nigerian, the entire revenue of the federal government of Nigeria. Oil revenue is a key part of it. So he began to fight, he began to speak up, he began to make allegations and claims, saying that certain persons, government officials, were ravaging the area, embezzling the funds, leaving his people in penury, the price of fuel had gone up, and whatnot. And so he was picked up by the police and slapped with a 5-count charge. Now, the charge was instituted at the Federal High Court because it contains treasonable felony. The court that has original jurisdiction to try at first instance treasonable felony is the Federal High Court. You'd recall that we've talked about hierarchy of courts in Nigeria on this channel, and we've talked about jurisdiction. Please watch those videos that we've done on those two aspects. So when he was charged, his lawyer brought an application for bail. Bail is asking the court to release a defendant before it. We're talking about court bail and not police bail. Please watch the video we've done on bail so that you understand the different types of bail. So his lawyer made an application to the court to release him on bail pending the trial. Bail pending trial just means release the defendant, let him be coming from his house to hear the case against him instead of being in detention throughout the case. So if he's convicted and sentenced, then he will go to jail and then he will serve his punishment. But if he's acquitted and released and discharged, he will just go home and continue living his life. So that's essentially what court bail is, or bail pending trial is. So the prosecution opposed the bail application, and then the court decided to deny the bail application after hearing both parties, because there was an affidavit for bail, a counter affidavit, and a further affidavit. So the court denied him bail at the trial court. Then his lawyer appealed the denial, the ruling on the bail application. You know that that's not the substantive matter. The substantive matter is a 5-count criminal charge, but on it was placed a bail application, which is very proper. Now, that's a motion. You come by way of motion when you're applying for bail. Now, for motions, the outcome is called ruling, while for the substantive matter or trial, the outcome is called judgment. So his lawyer appealed the ruling to the Court of Appeal. The Court of Appeal sided with the trial court and denied the bail again. Then his lawyer appealed to the Supreme Court, where he was again denied bail. It's important for us to look at this matter because it shows fortitude and conviction and a desire to see things through, which is something that I pointed out in Garba University of Maiduguri, the last judicial precedents that we talked about, which also went from the trial court to the Supreme Court. It's also instructive for us to look at this because it is a case that both prosecution and defense counsel can use. Ordinarily, if one party is using a case in support of their case, the other party shouldn't be able to use it because then it will be against them. But Dokubo, Asari, and federal government can be used by both sides in support of their case. It's fantastic, and you'll see why. It's also important for us to look at it so that we understand bail. The most important thing that we need to understand about bail in Nigeria is that it is discretionary. The grant of bail in Nigeria is discretionary. It's not automatic. There are several things that the court will consider, and it's on a case-by-case basis. So you can't say because the court has granted bail in A, they must grant bail in B. Or say that because the court granted A bail, denied B bail, then the court is prejudicial to B. No, that's not how it works. So now let's look at the case in total. Now, Dokubo Asari was picked up by the police and charged with treasonable felony. He was charged with conspiracy to commit treasonable felony. 1. I've told you on the channel before that most times the prosecution will charge with conspiracy, where there are more than 2 people that have committed the crime or have attempted to commit the crime, because in most cases, even if the substantive charge cannot be sustained, conspiracy can be sustained. That is, if you cannot prove that they actually carried out successfully the criminal act, you will most likely be able to prove that they actually planned to do it, that they conspired together to do it. So he was charged with conspiracy to commit treasonable felony. 2, with treasonable felony, which carries a life sentence. He was charged with forming, managing, and assisting to manage an unlawful society. That's 3. He was charged with publishing false statements, false information. That's 4. He was also charged with being a member of an unlawful society, which is a crime on its own. I've also mentioned on the channel that we once had the case. I was part of the prosecution in a matter where we had prosecuted some people for armed robbery, some persons for armed robbery, murder, and membership of an unlawful society. So these crimes can be found in the criminal code across different sections, and they can also be found in some laws of certain states. But this was the federal government prosecuting. So it was the Office of the Attorney General that was prosecuting this matter, essentially. So they prosecuted according to the criminal code. Now, after he was charged, his lawyer brought the bail application, deposed to an affidavit in support of the application. When you bring a bail application, you file 3 things: the motion for bail, the affidavit in support of the motion, and then the written address. Then the other party will respond if they want to oppose the bail by filing a counter affidavit and written address. And then you can file a further affidavit, with written address also. So that's how it works. So his lawyer brought an affidavit where they said several things. Essentially, they were saying that oh, this person has never committed a crime. There's no record of him having been prosecuted for a crime before, and he will not commit another crime. He doesn't know anything about these charges. He was just invited by the police and asked if he knows anything about the arrest of the Bayelsa State governor, and he denied involvement or knowledge of it. And then the police whisked him off from Rivers State Police Headquarters to Abuja, saying his attention was needed for some things. And they did not even let his friends and his associates that come with him to answer the police call that he answered. You know, they were not informed that he had been whisked away, via another exit. So that's how he found himself in Abuja, and now he's standing trial for these things. He doesn't know anything about these things. He will not commit any crime if he's released on bail. He will present himself for trial, because he really doesn't know anything about these things. He has not done the things that the government has accused him of, and on and on and on. And the defense counsel also brought, and then the prosecution brought a counter affidavit saying that this person did it. In our proof of evidence, we have filed a newspaper publication where he granted an interview threatening to fight until Nigeria disintegrates. That's a direct quote. This person is a member of and has assisted in forming and managing these societies. They listed the societies, about 3 different societies, and then they said that these are unlawful societies, and so he's managing them, he's a member of them, he formed them, he assisted in forming them. They also claim that he has made claims against the government, against government officials that are not true. And he has been threatening the government, threatening to overawe and overthrow the government, which essentially that is what treasonable felony is. We are in a democracy, but constitutionally, if anyone makes any act, overt or covert, targeted towards overawing the government, overthrowing the government, that's treasonable felony, and that person is going to be put away for life if found guilty. So these are the things that they brought against him in their counter affidavit. They also brought a statement in support where he had actually admitted some of these criminal acts that all added up to form the charges against him. Then his lawyer then filed a further counter to say that they also said, the prosecution also said that he's from the riverine area, the creeks, those places, has a lot of hiding spots. So if we let him go, he will just go into hiding, and we will not be able to find him. We have not even found many of his associates. So the charge was brought against him and others that are at large. That's what the prosecution does when they cannot find all the people they suspect committed the crime together, and especially if there's a conspiracy charge. If you are bringing only one person for conspiracy, you have to add that clause, and others that are at large. If you believe that they are actually at large, they committed the offense together, because conspiracy cannot be committed by one person. So this is what the prosecution put before the court. And then his lawyer saw a further affidavit to say that there's no shred of evidence tying this person to these offenses. He is not this kind of person. He will present himself for trial, and he will even provide sureties in the event of running away, which he will not do. He will provide sureties who can easily, search him out and present him back to court in those riverine areas. And then they said some other things. Now let's look at the conditions for bail. We've looked at the charge, we've looked at what both parties said, and the evidence before the court. Now, what are the conditions? What are those things that the court will consider before granting bail? The court will consider the following. I'm going to read it out so that I won't miss any. It's not exhaustive, but these are some of the important things, the most important things that the court considers. One is the nature of the charge, the strength of the evidence which supports the charge, the gravity of the punishment in the event of conviction, the previous criminal record of the accused, if any, the probability that the accused may not surrender himself for trial, the likelihood of the accused interfering with witnesses, or that he may suppress any evidence that may incriminate him. Him here is for both him or her, actually. The likelihood of further charge being brought against the accused, the probability of guilt, detention for the protection of the accused, necessity to procure medical or social report, pending final disposal of the case. So these are some of the things that the court will consider in the grant of bail. Now, let's look at them in the light of what both parties put before the court. The nature of the charge. The charge is treasonable felony. That's a serious offense. It is not a misdemeanor. It's not a simple offense. So it's a serious offense. It's just like murder now is a serious offense. Rape in Nigeria is a serious offense. So the nature is, it is serious. The court will consider that in deciding whether to grant bail or not. Even though the accused person or the defendant is presumed innocent until proven guilty, the court will still consider the nature of the charge against them. That's why it's important for prosecution not to just trump up charges against persons, because the court will consider the nature of the charge in deciding whether to grant bail or not. Now, 2, the strength of the evidence which supports the charge. Mentioned here that the prosecution, as part of their proof of evidence, put a newspaper publication which showed the accused person granted an interview to a daily where he threatened to continue to fight until Nigeria disintegrates, where he also said that the construct known as Nigeria is an evil entity. Essentially, he was speaking against the unity of Nigeria. He was speaking against law and order, inciting violence, especially against the government, seeking to disintegrate and to overhaul the government of Nigeria. Also, a statement was attached. The accused person has made a statement to the police. That's a confessional statement where they have also admitted to some criminal acts. As if you're a prosecution or prosecution counsel or prosecutor, you can also attach it as an exhibit to the counter affidavit. I'm speaking for both sides, not for one side, so let it be taken as such. So the strength of the evidence is that there's evidence in public domain even that this person has been inciting violence and threatening to overthrow the government, evidence that supports the charge. Now, on his own case, Dokubo Asari would just believe that he's fighting for the financial or socio-economic emancipation of the Niger Delta people. That's his people. You know, he was essentially saying that this oil is coming from our region. Why is our region so poor? Who are the people taking these monies, taking this revenue? Then he was mentioning names. This person is taking, that person is taking, this person is taking, the government is not fair to us, you know, the government should go, this and that should happen. So 3 is the gravity of the punishment in the event of conviction. There are other offenses, but the particular offense of treasonable felony carries life imprisonment. The gravity is serious. The previous criminal record of the accused, if any, will be considered. The prosecution could not exactly say that he had a criminal record, and the defense said in their affidavit that he has no criminal record, no prior criminal record. So that's 4. 5 is the probability that the accused may not surrender himself for trial. Now, when you look at the gravity of the offense and the gravity of the sentence attached to it, is it possible that someone that may be convicted based on evidence for life imprisonment will present himself for trial? That's to look at it on one side. On the other side, look at what the prosecution said, that, oh, Niger Delta is a riverine area, also full of creeks. If he goes into hiding, they will not be able to smoke him out. That is what the prosecution said. But the defense on their own end said that, oh, he can provide sureties that will smoke him out in the event, assuming without conceding, that he even decides to disappear into the creeks and the riverine area. So that's the probability. That's, you know, we are weighing both affidavits and counter affidavits and further affidavits, all 3 now, not even both, and looking at how they tie to the conditions, the things that the court will consider in granting bail. Now, the 6th one is the 6th condition or criteria that the court may look at is the likelihood of the accused interfering with witnesses, or that he may suppress any evidence that may incriminate him. really, is there any evidence to suppress? He can't suppress what is in public domain in this case, but he may interfere with prosecution witnesses. That is likely. That is very common. I've been part of the prosecution of a murder trial before, where the nominal complainant declined to come to court. As much as I spoke to him on the phone, tried to get him to come to court, we do not have strong witness protection in Nigeria. He said he cannot come because his life is in danger, because the person that was murdered on his facility, and the people that were standing trial, the person standing trial, are threatening to take him out if he comes to court to give evidence. So he was afraid for his life, he wasn't going to come. So the likelihood of the accused interfering with witnesses is something that the court also considers. Another one is the likelihood of further charge being brought against the accused. This was very likely. They had accused him of publishing false statements, inciting violence, trying to overthrow the government, and so many other things. It was very likely that as the case went on, the prosecution would be able to build up more charges or bring more charges against him. The probability of guilt. Now, that's for the courts to look at from what has been placed before it. So you also look at it, assuming you are the court now, from what has been placed before the court. Would you say that Dokubo Asari is guilty? Now, detention for the protection of the accused, that's something that the court looks at. So the court could say that, oh, Dokubo Asari, for instance, if we put you in custody and we don't grant you bail, you may even be safe in our custody. That may not apply to this case, but in the case of if someone has committed a crime and an entire community is incensed against the person, they may even be safer in custody than going and coming from their house, because someone can decide to move faster than the law and take them out. So very important. The necessity to procure medical or social report. In the prosecution's counter affidavit, which the defense probably omitted or did not avert their mind to, they stated that the defendant, accused person, is in good health and is being taken care of by the state properly where he is in detention, as can be seen from the last time he came before the court. So the defense did not say anything to that, which is probably an omission in a plethora of bail applications that I've had to respond to, that I had to respond to when I was a prosecutor. Most of them, or a good number of them, would claim health challenges. Some would even go as far as saying that, oh, this person, he uses natural herbs and he needs to go see his herbalist, or he needs to be out of prison so that he can have access to the herbs and the local medication that he's using for his illness or ailment. Some would even attach a medical report to show that this person has a chronic disease and will not receive utmost medical attention in custody. Of course, we all know, or maybe not all of us, but it is a fact that the state of medical care available to people in detention in Nigeria is deplorable and not up to par. So sometimes if you're able to bring a medical report, especially from a government-owned hospital, it is it increases the chance of getting the bail. So most defense counsel know this. Most defense counsel know this and they do it. So those are some of the things that the court will consider. You can also look at Bamaye and the state, Abacha and the state. These are very notorious cases that we all use as criminal litigation lawyers. And these cases also outline criteria that the court looks at in granting bail. So this is not an exhaustive list, but this is what the court looks at in general. Now, in this case, the court held, first court said, no, we're not granting you bail. Second court said, no, we're not granting you bail. Now, third court, that's where we are now, the Supreme Court. Let's look at the issues that both parties formulated for determination and how the court eventually decided. For the appellant, that is the defense counsel at the trial court, that's Dokubo Asari and his lawyer, his team, the defense. They are now the appellants at the Supreme Court. They were the appellant at the Court of Appeal, and they are now the appellant again at the Supreme Court. The issues they formulated two issues for determination. They are: one, whether the Court of Appeal was right when it reached a conclusion of fact that there was acceptable evidence of threats to national security by the appellant in the case put forward by the respondent. At the Supreme Court, the appellant, that is the defendant, has at the trial court, who became the appellant at the Court of Appeal and now the appellant at the Supreme Court, formulated two issues for determination. And they are: one, whether the Court of Appeal was right when it reached a conclusion of fact that there was acceptable evidence of threat to national security by the appellant in the case put forward by the respondent. Two, assuming without conceding that the case of the respondent revealed a strong prima facie case of threat to national security, whether that suspends the right to bail as enshrined in Section 35 of the 1999 Constitution. Then the prosecution, who are the respondents, now formulated one issue for determination, and that is whether, in view of the totality of the facts and circumstances of this case and the evidence properly before the trial court, the court below was right when it confirmed the decision of the trial court. Let's look at how the Supreme Court decided. Let's start from issue one. The issue one, formulated by the appellant, was essentially asking the Supreme Court to decide whether, from what the charges, the totality of the case of the prosecution, there's proof enough that the accused person posed a threat to national security. That's issue one. Issue two is to say that even if they now pose a threat to national security, does that give way to the suspension of their constitutionally enshrined right? There's presumption of innocence, right to personal liberty, all those rights. Now, on issue one, the court now looked at the totality of the case of the prosecution, like they asked, and the court decided that this person actually poses a threat to national security. In the first instance, the court referred to an interview that Dokubo Asari granted in the Independent newspaper in September 2005, where he had promised to continue to fight until Nigeria disintegrates. One. Two, the court looked at the statement, the confessional statement he made to the police, where he said a lot of things. I want to read out some of the things in the confessional statement here. He said that the objective of Pro-NACO, which is one of the unlawful organizations that he belonged to, was to organize a sovereign national conference. The conference will kick off in October 2005. The Niger Delta Sovereign National Conference is a mini conference of the Pro-NACO People's National Conference. Because General Olusegun Obasanjo manipulated himself to power through massive rigging of the 2003 election, the people must seize power through the process of democratic, progressive mass action that will lead to the formulation of a provisional government of national unity. We can achieve peace without fighting by going our separate ways, like the Czechoslovakia experience. If there is no peace, the process leading to armed struggle cannot be ascertained, as I am not God. The Niger Delta People's Volunteer Force, which I led, has totally disarmed. Hence, armed struggle will predicate on the actions and activities of the regime of the Nigerian state. I will pursue the course of the disintegration of Nigeria through the process of the People's National Conference. The government of General Obasanjo is illegitimate. It retains power through the manipulation of the electoral process. This is a negation of elementary principle of democratic governance. No man with self-respect will allow his right of choice taken away from him by a regime claiming to be democratic. This has made me and others like me to resent the government of the regime of General Obasanjo. When Nigeria eventually disintegrates, the Ijaws will form a country of their own. If the struggle outlives me, I will be grateful to God for others better than myself, such as Isaac Adaaboro Ken Sarowiwa, who had gone before me. So that's a direct quote from his confessional statement. So the court looked at these two documents. That's documentary evidence now. It's not even, let's say, documentary evidence, where he was pro overthrowing the government, pro overawing the government, pro disintegrating the unity of the country. And you know that there's a constitutional provision that the unity of Nigeria is non-negotiable. So these are things that the court considered to say that on issue one, there's actually proof furnished by the prosecution to show and to prove that this person poses a threat to national security, because he says he cannot guarantee peaceful disintegration. Of course, there's no disintegration that can come peacefully in most cases. So essentially, the court said on this particular issue, it poses a threat to national security. Who knows what the country could descend into if this is allowed to be carried out. Now, the second issue is that even if he now poses national security, is that enough to deny him his fundamental human rights, his constitutionally assured rights? Let's look at issue 2 now. On issue 2, the court held in 2 ways. The first is the popular dictum, which is also something that prosecutors use in their counter affidavit. The court held that where the right to personal liberty or the fundamental rights of an individual is colliding with the interest of the state or the national security, that personal right will bow to national security. That's what the court held in Dokubo, Asari, and FGN. That's on one side. On the other side, the court then held that the rights contained in section 35 of the Constitution are not absolute rights, they are qualified rights. So for instance, let me read section 35 to you. It says, every person shall be entitled to his personal liberty, and no person shall be deprived of such liberty, save in the following cases. So those cases are qualified it, and the court was able to decide that those qualifications apply to Dokubo, Asari in this instance. 35(1)(c) says that for the purpose of bringing him before a court in execution of the order of a court, or upon reasonable suspicion, that's the part that applies, of his having committed a criminal offense, or to such extent as may be reasonably necessary to prevent his committing a criminal offense. The court held that those parts, those qualifications apply to Dokubo, Asari. Then it went on to quote subsection 4, subsection 7. Subsection 7a of section 35 says that nothing in this section shall be construed in relation to subsection 4 of this section as applying in the case of a person arrested or detained upon reasonable suspicion of having committed a capital offense. Now, subsection 4 talks about the time frame within which any arrested person must be released or charged to court. But it now says in subsection 7 that it will not apply to someone that was arrested or detained upon reasonable suspicion of having committed a capital offense. So all these things the court held was in the favor of the prosecution to deny the appellant, which is Dokubo, Asari, bail in this matter. But I want to read the particular dictum of national security and personal liberty, personal rights, individual rights, because it is one of the most important dictums or dicta that emanated from this particular case. The pronouncement by the court below is that where national security is threatened or there's the real likelihood of it being threatened, human rights or the individual rights of those responsible take second place. Human rights or individual rights must be suspended until the national security can be protected or well taken care of. This is not anything new. The corporate existence of Nigeria as a united, harmonious, indivisible, and indissoluble sovereign nation is certainly greater than any citizen's liberty or right. Once the security of this nation is in jeopardy and it survives in pieces rather than in peace, the individual's liberty or rights may not even exist. So this is what the court held. Additionally, the court also held that although the applicant had claimed that the prosecution did not furnish them with proof of evidence, which is, you know, a fairly popular claim with defense counsel, the court held that it could actually find before it, in the totality of the case file, it could find depositions by a lawyer in the law firm of the defense counsel who had undertaken and deposed to an affidavit saying that they were served the proof of evidence, they applied for it by a letter, the letter was acknowledged, and that they received the proof of evidence. So that also did not hold for the applicant. Also, the statement that was attached to the counter affidavit, that's the confessional statement where the applicant had said all those things, that he was going to lead a national conference, was going to see to the disintegration of Nigeria. That statement was not controverted in the further affidavit of the defense counsel. That's on one side. On the other side, the prosecution had said that granting the accused person bail constitutes a threat to national security. The defense counsel did not also controvert that. What can we learn from this? Bails thrive on affidavits and affidavit evidence. So if you're deposing to anything in your affidavit, it must be the truth, the whole truth, and nothing but the truth. So if you're lying on oath, that's perjury. And so claiming that they were not served proof of evidence, or that the prosecution did not attach proof of evidence when they had also deposed earlier that they applied for proof of evidence and received it, was falsehood. Also, we have also learned that it's important when you are served a counter affidavit as defense counsel, or if you are if you're the prosecution replying to an affidavit, you must controvert everything that you do not agree with in the other party's affidavit. Do not leave it to chance, because it might be deemed an admission. So these are the important things that we can learn from Dokubo, Asari, and federal government of Nigeria. It is still a relevant case today. It's the Supreme Court decided in 2006, but almost 20 years later, it is still relevant. Let's continue the conversation in the comment section. I will see you in my very next video. Don't forget to subscribe and bring a friend along to Battle with Ola. Toodles!